My name is Kyle Mayers. I'm the Executive Assistant with the Boulder County Bar Association. And I want to thank you all for joining us today for this great solo small firm presentation. I'm going to be introducing Joe Enzor, who is our incoming section chair for the solo small firm section. And he's going to be introducing Kurt Hofgaard, who's our event sponsor today, Hofgaard Insurance. And I just want to say thank you to Jody Martin for presenting today. And let me turn things over to Joe Enzor.
Hi, everybody. I'm Joe, and I was roped into this august title. So I'm looking forward to being the new solo chair there, the chair of the solo and small practice section. I've been a practicing attorney in the Boulder region for about 20 years. I practice largely complex transactions, mergers and acquisitions, some tax law. I have a master's in tax as well. And prior to that, that's a second career, actually. My first career from which I retired was as a senior executive for a number of technology companies, mostly on the West Coast. So I have a background both in business and in law, and that's sort of my angle on my practice. Today's program is sponsored by Hofgaard Insurance, and its principal is Kurt Hofgaard, and I think he's waiting to give us a message about his firm and about his sponsorship. Kurt?
Oh, great. Well, thank you very much. Well, I also have two jobs. Many of you know me as an estate planning attorney, but I've also worked in the insurance industry for 25 plus years. Actually, my father started one of the first independent insurance brokerages in 1956 in Boulder, and I've continued that business. And so Jody's going to be talking to you a lot about succession planning. I can help you with that too, with Hofgaard Insurance. Life or disability insurance can be the engine to drive a successful business succession plan. So you have a buy-sell contract in place. Well, that's great. Congratulations. Now, when the time comes, when the owner dies or becomes disabled, how is the successor owner going to pay? Loans from the family or additional loans in installments? Why not upfront? So A, the family recognizes the full value of the business, not to be involved in the business any longer. And B, the successor owner is free from any deceased or disabled owner family involvement or obligations going forward. If you'd like to talk more about options for life or disability insurance, I would be glad to talk to you about that. So thank you for allowing us to sponsor the program today, a really important topic. It's my pleasure to introduce Jody Martin, my colleague in estate planning. Jody's the founding attorney at Martin Law Office, LLC. She has over 25 years of legal experience, including extensive trial litigation and appellate experience. She's admitted to practice in Colorado and Oklahoma, as well as the federal district courts in Colorado and Oklahoma, the 10th Circuit and U.S. Supreme Court. She has many other great qualifications that are too long to list here. But I'm glad to be a colleague of Jody's and also on the board of directors as well. So with that, I will turn it over to Jody. Thank you.
Thanks, Kurt, and thanks, Joe, and thanks for running the section this year. We appreciate your work on that. So welcome, everybody. I'm going to share my screen, and we're going to talk about succession planning. All right, you should be able to see the cover page on our PowerPoint. And just so you know, as we start through some slides, Kyle does have a set of slides that he'll be able to share with you after this. So you'll have the slides if you want to look back at them. I'm not going to tell you they're the best thing in the world, but they might get you by. So also, one of the things we'll talk about today is a manual that's put out by the Office of Attorney Regulation Council. And just so you know, there's a link to get to that, which Kyle will provide as well, I'm sure. And if we have time, I'll put it in the chat as long as I remember, but it's available through OARC, and we'll talk briefly about that. So as mentioned, I am an attorney here in the Boulder area. And my firm focuses on estate planning, probate litigation, those sorts of things. And part of what my firm does is also work with folks on succession planning for a variety of different types of business structures. So for instance, therapists sometimes run into some of the same issues that attorneys do. So we have similar types of succession planning set up for therapists, and that's because of the licensing requirements. But as attorneys, we frequently hit issues that sometimes I think we get so busy with our practice, especially as a solo practitioner. I am a solo practitioner. Solo and small firms, I think we kind of get inundated with trying to keep things moving, plus practice as attorneys and do the back office work. And so we sort of set to the side the idea of what happens if. And so I frequently work with attorneys as well on that. So the first thing you're going to see in your slides is numbers. The reason I'm going to give you a bunch of numbers is, number one, we're going to talk numbers and some ethic issues, which helps get you a little ethics credit with this, hopefully. So the first thing on your screen is active attorneys. And so in Colorado, we currently, according to the numbers you're going to see here, are all from OARC's 2022 report. So that's where these numbers come from. In 2022's report, we have a total of 28,292 active attorneys. So that's total active attorneys. This is breaking that down by age, because I kind of use 50 as the breaking line. I myself have hit that marker. And so I find that I think when we start thinking about succession planning, definitely as we get older in our practice, I think it becomes more maybe real, but this applies to every age. So I did break it down to give you some idea. You can see that we have some folks still practicing over the age of 90. So that's your active attorneys. Then we're going to break it down by type of firm. There's 5,271 solo practitioners out there and 4,972 small firm, and they define small firm as up to 10. So yeah, I mean, I don't think all of us in the world that are practicing as attorneys probably think of a small firm anymore as up to 10, but that's the way OARC classifies them. So keep that in mind. But I do think what's important to understand here is that 21% of active attorneys, of practicing attorneys, are solo practitioners. So that's a big category. And it's significant here because we're at a higher risk of not having succession stuff in place and a problem happening. And we'll talk about why as we move forward. So these are the solos by the number. You can see we've got, this is of practicing attorneys. 1,397 of them are ages 60 to 69 and so forth. That's 35% of solo practitioners basically are 60 to 69, and that 49% number is not, it's not 49%. So I'm not sure, my math is off there. So I apologize. 38% of solos do not have malpractice insurance as of the 2022 report. That's actually down, just so you know, from 2021. We were closer to almost 50% without malpractice in the prior reporting. So that number has gone down, which is good. All right, so now let's talk ethics to help you with that ethics credit, hopefully. So when we talk about succession planning, we actually have, as solo practitioners and small firm practitioners, every attorney as part of our ethics code, we have an obligation to think about succession planning. Nothing specifically in, you can't like flip to a rule that says succession planning, but what you will find is the rules kind of dance around it, and then there are some comments that directly address it. So 1.1, the duty of competent representation. We have a duty to safeguard our client's interest. And so if we haven't done our succession planning and nobody is dealing with, we've died suddenly or we're incapacitated suddenly and nobody's dealing with our cases or the money sitting in our accounts, then the question becomes, have we met that rule, since we have not planned for all of those kind of potentials. Duty of diligence, 1.3. This one actually is the one that has a comment, and the comment specifically says that solo practitioners should be preparing a plan in conformity with applicable rules that designates another competent lawyer to review client files notify each client of the lawyer's death or disability, and determine whether there is a need for immediate protective action. So for solo practitioners, there is a specific comment to 1.3 that puts an additional burden on us to make sure we've taken care of these things. 1.15, safeguarding the property of clients and third parties. That could be everything from property that you're keeping in your office, but it also could be if you're doing, say, litigation or probate administration, and you're dealing with the property of folks, and you suddenly are incapacitated and there's not anything lined up to deal with their property, that's a problem. But it could also be your trust account. One thing you'll hear as we move forward, and so I'll just put it out there now, is the fact that nobody, and you may remember this from when you set up your trust account, but the only people that can manage money in your COLTAF account or your trust account is another attorney. So you might say, well, you know, I've got a power of attorney, you know, my spouse has my financial power of attorney. If something suddenly happened to me, I know they could go in and use that in certain ways to try and deal with the firm and manage things. But if they're not an attorney, they will not be able to get access to that trust account, even if you've got some documents in place authorizing it. Even if they're somehow on your accounts, like your bank allowed you to do that, if they are not a licensed attorney, they're not supposed to touch trust money. So you could just be in violation of 1.15 in that way if you can't get to their money. And then some malpractice carriers actually require you to do some succession planning, at least having a coverage attorney, which we'll talk about today. So it depends on your carrier, but a lot of them have started even asking solo practitioners to fill out that information. I have to tell my carrier every year who my coverage attorney is, and if I have one. And I don't know what happens if I answer that I don't have one, because I always tell them I do, but they definitely ask. So now that we've talked about the ethics rules, and we will kick back to a couple other ethics rules as we continue, but the question that comes up next from a lot of people is, you know, when would this even apply to me? Like, when do I need to worry about succession planning? Because I'm fine now, I'm healthy, things are operating, I want to put it to the side burner. Well, the reason that succession planning comes up is not just in the instance of passing away. I mean, that's kind of the most common thing, even in my estate planning practice, where people go, I'm worried about my stuff when I die. But as any estate planning attorney practitioner will tell you, we want to talk also about things that happen during your lifetime, because there is a good chance of incapacity or impairment. But also when we talk succession planning, we think about vacations, or maybe a sudden disbarment or suspension or a retirement, as well as death. So it's not just focusing on the what if I suddenly die. All these other areas can create some issues that you need to sort of have some backup plans in place to deal with. So let's talk some definitions. I should have said at the beginning, I'm going to move a little quickly through some of this potentially at times. So if you have questions, I definitely welcome those. I think if you put them in the chat, I will circle back to them at the end. My goal is to make sure I leave plenty of time for us to answer those questions and any others that you might have that we didn't touch on today. So definitions, just so we get some base level understanding. Coverage attorney, which I have mentioned a couple of times. This is really, this is just generally kind of a verbal arrangement for most people. This is that attorney, especially for a solo practitioner. Small firms, it's sort of built into the practice, because small firm, meaning that you have at least one other attorney on top of yourself in the practice. So, you know, presumably your partner or associates are going to know when you're out of the office. So that is sort of your built-in coverage attorney. But for solo practitioners, you don't have that cushion. And so what you want to do is have an agreement with some other attorney, and it could change depending on when you're going to be out of town. Sometimes it changes for me based on when I'm going to be out of town and the nature of cases that might pop up, given how active certain things are for me. I have a heavy litigation practice in the probate arena, but sometimes I'm doing some family law or adoption sort of work. And so if those are more active at the time, I might engage a different coverage attorney. But this is somebody that's going to cover like an emergency hearing if it comes up, presumably you've scheduled all your hearings to not happen while you're out of the office. But if I'm going on vacation, I might say, hey, if I have an emergency hearing, are you going to be around and available to at least step in, get a continuance, do whatever needs to happen. But also client emergencies, staff emergencies. So if you're a solo with a few staff members, you never know what's going to arise in that context. I have 2 different staff members in my office, and any number of things can happen. They always know who they can call if something comes up. It could be a client emergency and they just need some help with it. Usually it's for a specific time period or an instance, like a vacation, or if I was having a surgery of some sort that might kind of take me out of pocket to where I couldn't be accessible. And it's generally limited nature. We're not giving them any releases. We're not giving the coverage attorney access to our finances or really even most of our files. It's sort of that on the fly emergent kind of an issue. They're usually going to be on call, that sort of thing for your staff. And so that's a coverage attorney. Usually pretty easy to sort of make that arrangement with a fellow solo or a friend that is a small firm or even a bigger firm. But that's what you're looking for there. Then we're going to define an assisting attorney. This is someone with authority to actually run your practice, generally temporarily. The idea being they're either going to be sort of running it while you're incapacitated with the idea that you're returning, or they're going to be running it temporarily with the idea of kind of wrapping things up so that it can be closed, whether that's because your incapacity is going to be indefinite or because you have passed away. But this is somebody set up with authority to really come in, all hands on deck, and have a lot of access and be doing quite a bit of stuff. We'll talk a lot more about how this role works, but this is just to give you a general understanding of the definition. They likely do have access to your COLTAF account, but this requires formal documentation. So this is part of that succession planning that we are talking about. All right, inventory counsel, another term you're going to hear today. Inventory counsel is a position at the Office of Attorney Regulation Counsel. It is a lot of people, if they haven't really had occasion to come in contact with this area of OARC or attend a CLE or get kind of work in this area, may not know that this office exists. But there is an individual at OARC who is titled or holds the position of inventory counsel, and they have a very specific job. They have some staff. Their job is to be appointed by the court on application of OARC to handle a practice. And generally, they're coming in to close it down. They're not going to come in and cover your practice while you heal from an emergency surgery or an emergency incapacity. They're going to come in and shut it down. So they also can reach out to attorneys for volunteer positions. So if you find this interesting, they frequently are looking for volunteer attorneys in various areas, like especially in the high country and different things where it's harder for them to send their staff. So they have they come into play when the attorney has hit one of these 4 categories. So basically, it is a long-term situation, and there's no other responsible party capable of conducting the attorney's affairs that is known to exist. Again, the spouse is not generally considered capable of conducting the affairs if they're not a licensed attorney. Additionally, if they were employed, like my spouse is an attorney, but employed with the federal judiciary, so she could not come in and conduct my firm's affairs because of the requirements on her position with the federal government. So they have authority through CRCP. The rules are cited there for you. I won't give you that quote, but they have authority there. And there's a procedure to get appointed. They apply to the court and they go through a special process. And then they are directed to come in and review all of your client files and take steps necessary to protect the interests of the attorney, but also the clients. So they can disperse funds from your COLTAF, because again, they're shutting things down. They can come in and seize computers, and they will come in and access computers. They will seize laptops, phones, anything that has firm information on it is going to be taken into their custody. In talking with inventory counsel a few different times when we've done this over the years, I know for a fact that's one of the things that comes up as bothersome to some folks, is the idea that they're going to come in and take your laptop. And so if you've got, family photos stored on there, those are going to be secured for a while by inventory counsel. And what they tend to do, according to the conversations I've had with them, my understanding is they tend to try to sort of pull off that personal photos so they can give those to the family. But when they are done, they're probably going to wipe that laptop because they need to make sure your client information is gone. And the same things go for your phone. So you kind of keep that in mind, because the reality is, with our phones, most of us in today's world rarely carry multiple, and we do tend to do multiple things on our phones. So keep that in mind as you're kind of setting up your technology, that's one of the things. If you haven't done your planning, this is what inventory counsel is going to do, because they aren't there to spend a lot of time piecing through this, right? They're there to focus on certain things and get to an end result. So these are the inventory counsel numbers. Again, this kind of goes towards ethics, but also it gives you some sort of sometimes some shock. This is 22. Inventory counsel at OARC, they returned $793,000 plus to clients from trust and business accounts in just 22. I will tell you that is much higher than I've seen in years past. I'm guessing they must have had one or two cases that they were handling that were just some higher value kind of situations. And then 13,000 plus was sent to the Trust Account Foundation because it was unclaimed funds that were they were clearly client funds, but they were unclaimed, or they could not identify them as being funds the firm was entitled to. And so therefore they sent them to the foundation. So that's 13,000 that either the attorney is without, or the attorney's family, or some clients. They did file 15 new petitions in 22. Some of those were handled by volunteer counsel, who's under the same directives and parameters as inventory counsel themselves would be, because it's all run the same. And they collected 131,000 plus from, and that should be plural, from the attorney's estates to return to trust accounts. So what I mean by that is they're reporting that there was 131,000 plus that had not been kept in trust funds in some way. So they recovered them from the estate or estates and pulled them back so that they could go to the clients, because they were, whether it was money that was improperly moved, either way, probably improperly moved, but either not accounted for properly, or they couldn't define how the money had disappeared. So they have to reach out and collect it. So those are their numbers from 22. I will tell you as well that the other thing I know they have started doing, they didn't used to do this, but due to finances, I know that if they're appointed to serve as inventory counsel, they now have authority to be charging the firm and or estate for some of their expenses. So there's a way that they can start recovering some of the costs that is incurred by OARC in going through this process. I can tell you this takes a long time. They have to go in and go through all the files in your office, all the technology to find the files, go through the paper files. And they'll walk into some offices and folks are paper heavy. They do not clear out old files, and maybe they don't even have a destruction policy in their records. And so now OARC is sending these notices to multitudes of former clients so that they can start destroying files. And so it can take a while for them to work through your stuff. And what that can mean is that your family, you may have a bunch of money sitting in the operating account, and your family can't always get access to that because they can't confirm that it's supposed to be yours and not go to a client. And so there's just a lot that's paused while they do this process. So now that I've said all these scary things about inventory counsel, I will tell you they're great people. But it's just not what most of us want. So what we're going to talk about today is how to avoid inventory counsel, because you can do some things to plan for yourself. Just like with estate planning, we're trying to do things so that I can control what happens and who's doing it. That's what succession planning is about. And so that's what we're going to keep talking about. All right, so shifting gears from definitions, what sort of issues are going to arise if I'm temporarily absent? So absent. I mean, come on, if I have a bad car accident on the way home and I'm severely injured and hospitalized, but it's temporary, but I can't focus on, work or even really be able to function that level, but they're telling me I'm going to be better in, 3 to 6 months or something, or even 2 months. What could potentially happen? Well, most of these are really pretty common sense. We just don't necessarily stop and think about them, but it's everything from court dates to those client deadlines and commitments, but it's also keeping our firm alive, right? You've got a pipeline that you've probably started. I mean, you've started some sort of pipeline to keep your business functioning. And if you're not there to keep that pipeline moving, is it just going to stop? Because if it stops for 2 to 3 months and you're a solo practitioner, what do you do when you come back, right? Because now you're back, but you've dried up in that period. Well, if you have some plans in place, the theory would be maybe there's some movement to the pipeline. Oh, Jody's not available, but she'll be back in, 45 days. We're fairly confident. Let's get you on the schedule, or send that paperwork in, and let's see what we can do to keep you on the calendar. So the idea is to hopefully keep it functional if I think it's temporary. Income, same thing. If there's nobody in there issuing those bills that I've got all my invoicing and billing set up, but there's nobody issuing it, then my income has stopped, most likely, unless I've done some other things to protect it. And so trust account employees, I have 2 employees. I'm fairly confident they rely on their paychecks for their expenses and their families. So if my work is stopped because of a temporary absence, what happens to them if there's nobody doing the invoicing to get the money in to then pay them, right? Even if I've worked solid and I have it, if it's not coming in, how am I paying them? Your office lease and expenses. So what are some solutions? Those are the problems, right? We could probably go on and on. I could have probably filled up 3 slides with those scary ideas, but is there a solution? And yeah, there are. So one list of solutions for temporary absences would start with keeping things up to date, right? Keep your billing up to date. For some of us, that's a difficult task. Most of us that have that as something that's a difficult task, we sort of know that going in. There are some people I know that are on top of their billing. They finish their day, they make sure it's good to go. But having worked with a lot of different attorneys over the year, I know that's not the case for everybody. So the idea is to keep that billing up to date. And then also your file notes and your information in your files, keeping it up to date. Because that's where your coverage attorney, if an emergency arises, is going to look, right? So keep those notes and information up to date. Calendar management so that people can see, where do you need to be? Jody had that bad accident on the way home. Oh my gosh, she had a mediation 2 days later. We need to move that, right? If my calendar is not up to date, then my staff or my coverage attorney can't deal with it. Your staff should know your systems, really. And that sometimes is tough, but there's some training that has to happen there. And you kind of want to make sure that you're on top of keeping those affairs in order. I think there might be, if anybody's having a little feedback, let me know, or I'm not sure if somebody else is maybe not muted or if it's just on my end. So cross-training. If you're a small firm, cross-train. Even an associate that maybe doesn't have all the ins and outs of the management of your practice, make sure they're cross-trained at least in kind of coverage things. Even if they're a newer associate to your firm, there are some things that if you at least train them on, the emergency protocols so that things aren't dropped if you're temporarily away. That is part of succession planning. Disability insurance. So I know that Kurt talked to us about that, but disability insurance, this is how you're funding your loss of income. If there's nobody to do your billing, If you've got somebody in place that's helping with your billing to make sure your finances keep going, then disability insurance might be a little less of a concern. However, if you have a long-term incapacity that's still a short-term absence or a temporary absence, this disability insurance could be the difference between paying your personal bills and not being able to keep up with those. Coverage attorney, again, that could be a coworker, or for a solo, it could be any other attorney, you know, similar practice or not. Somebody that's willing to just be available for that moment. And generally, you're doing it in return, right? I know the attorneys I do this for, or that cover for me, I'm their coverage when they're traveling. Sometimes I'm like, man, you get to travel more than I do. You do better planning of your schedule. But, you know, maybe that motivates us to do more vacations. I don't know. But the idea is to have somebody there. Power of attorney. So when you do your estate planning, you can do a power of attorney, right? That's just this general financial power of attorney. Maybe you give it to your spouse during your lifetime, and then somebody else is a backup. But you can do a limited power of attorney, and that gives someone access to your finances, even your trust account if it's done properly, on a temporary basis. And so if I have that bad accident and I've got a limited power of attorney with attorney Jane Doe, then Jane can step in and at least make sure I get paid for billing that needs to be done, or make sure my clients get their retainers back. If somebody's got a hot litigation matter and they can't wait for me to get better, totally get it. They're entitled to their retainer back. We need to make sure we get that taken care of. You can also put an authorized signer on your accounts if you're a small firm. Again, that's kind of an easier maneuver if you've got somebody you trust to do that within your small firm, or if it's a partner. But if you're a solo practitioner, then again, you need to think through who that would be. And if you've done a power of attorney limited and notified your bank, that might be enough of a solution so that maybe it's only effective if you're incapacitated and you don't have to worry about the day-to-day. But truthfully, if you're giving someone access to your finances in any way, you kind of need them to be somebody you trust. So you kind of want to think through, if there's times you don't trust them, maybe that's not the right fit. And then an assisting attorney, and we've talked about the definition. We're going to circle back to that a little bit more. But that's another option, even for a temporary absence. So with a temporary absence, if I've got all of the assisting attorney paperwork set up, then I know that there's somebody that can come in and do some things to keep my firm alive if I've had that accident or that illness that incapacitates me temporarily. That's not what you're going to use if you're just taking a vacation, right? So temporary is pretty broad. You're just taking a vacation, that's your coverage attorney. But if you have had an accident and you are, you know, have a traumatic brain injury that you can recover from, and so they've said, yeah, Jody's going to come out of this, or you're having, treatment for cancer that's really taking you down. Maybe that's when your assisting attorney is what you need instead of your coverage. So when you do your plan for an assisting attorney, you want it to be potentially broad enough that they're not just walking in and shutting down the shop, that they have some authority to, if you want them to, you get to decide, but to operate it during these incapacity periods, so that it's staying there for you. Because theoretically, most of us, if we have something that is a temporary situation, we have the idea that we hope to return. Now, if we can't return at some point, that assisting attorney could then wrap it up, right? And also, if we've done our insurance, we have long-term disability insurance coming in and helping us with our finances, right? So we're sort of covering all those gaps by doing that succession planning. So that's temporary absence, and some of the options that you have for sort of dealing with or putting in place some planning for a temporary absence. And again, temporary is so broad. Permanent, not so broad, right? Permanent absence means not coming back. Now it could be it's a temporary that became a permanent, but it could just be that I've died, right? But whatever it is, I've got a permanent absence. So what sort of issues could arise? Well, I mean, we can all kind of think through some of the, the scary things that might happen if just suddenly, my life ended today, right? Everything from the court dates to the client deadlines. Also, though, would be getting some value out of this firm that I've built for my family, right? Because at the end of the day, I mean, this is what in some level has supported my family, maybe not entirely, but I'm relying on it for something, rather than just the, fun and giggles. There's something else here that causes me to do this every day. And that's something I probably don't want it to die and be a zero value at my death, or even a negative value. I probably want to see some value go to my family. But at a minimum, I don't want it to cause inventory counsel to knock on the door and say, hey, family, we need $100,000 from the estate because there's this stuff we can't track. And so here's, give us a check kind of a thing, right? That's probably not my goal. Also, issues arise from the trust account. Folks that have employees, big issue arises with employees because my passing could mean suddenly that two people are literally without a job unless I've done some succession planning. Your office lease, depending on how that's written, a lot of times when people have passed that have businesses, we see leases that have to be bought out. Now, sometimes you can negotiate those, but in today's commercial leasing market, I haven't dealt with it lately, but I'm not going to think that it's going to be easy to negotiate those. But most of the time there's some buying out that has to go with that lease. Plus you got an office full of stuff, right? So they probably need some time to deal with all the stuff in the office because not just anybody can handle your client files. And inventory counsel is probably going to come in if I haven't done my planning and need time in the space. So I'm still paying that lease. Avoiding litigation and bar complaints, because that's truly why litigation or inventory counsel exists, is in part because all of this, if we don't do anything, all of this just snowballs, right? Client can't get to his retainer, so he can't pay for the new attorney, so he can't defend the lawsuit that's going on, or he can't defend the criminal charges because he doesn't have any money. And, or you've already entered an appearance and he can't handle getting a new attorney because of that, or trials tomorrow. All of those sorts of things, what they lead to is bar complaints. Even though you've passed away, what happens then is malpractice litigation, right? And so now you've got money going out and you've got claims against malpractice, and it just can be a mess. And so if you are thinking about succession planning, what you're doing is trying to kind of stop that from happening. So let's talk solutions. So now we talk about some of these will seem pretty basic, but things like we've talked about before, keeping your billing up to date, your file notes, calendar management, your staff, and cross training. So those are the same. But adding to that pile, life insurance, a buy-sell agreement. If you're in a small firm, this is relevant. Solo practitioner, you don't have somebody in the firm to do a buy-sell agreement with. You could theoretically do one with a non-member of the firm. It's really kind of less likely, but more likely with your buy-sell agreement, you're looking internal in your firm with an arrangement of somebody buying out your interest in this firm. So your partner buying out your interest, or the firm buying out your interest, so that your family gets money, your value out of the firm, and you need to document that. And like Kurt mentioned, how do you pay for that, right? So it's great to have an agreement with your partner that says, if one of us dies, the other one will buy us out for a fair market value to be determined, blah, blah, blah. And we define how that's determined, or buy us out for X amount, whatever it is that we decide to set up. That's great on paper. And we both take comfort in that. We walk away and we go, whew, we heard Jody's thing, we got it squared away, and we heard our business attorney, we're good to go. But then somebody dies. And now suddenly you've got a buy-sell agreement and you're being told, well, you owe the estate $400,000 to buy out those shares, because the value of the firm or the value of the agreement was, $800,000, their share was $400,000. Well, you don't have $400,000 in the bank. So how are you going to buy that out? Well, if you've got a life insurance policy, and this can be owned by you as an individual, but more likely what happens is the firm buys life insurance policies on, let's say it's a 2-partner firm, so on each partner. And so then, partner one dies, and then firm says, okay, we have cashed out the life insurance policy and it paid $500,000 into the firm, and the buy-sell agreement says that 400 of that is going to the deceased partner's family, and then the surviving partner owns the entire firm, or however you set it up. You talk to your business lawyer or your succession planning lawyer, and you get that all figured out. Multitude of ways to work it out, but the life insurance has saved the survivor because now there's some money to do that buyout. Additionally, the life insurance has provided some padding because if you've lost an attorney, you probably have lost some ability to bill, and so you've got overhead, and so you've got a cushion built in by having a little more insurance than you needed for the buy-sell agreement. Shareholder agreement, similar concept. Your shareholder agreement may have some terms in it as far as what happens to the other shareholders' interest or either shareholders' interest at their death. That could be that their shares are assigned to somebody. It could be that you buy them out. It really depends how you've written it, but there's options in there. Again, the question usually comes back to money. How are we going to make that right so that people are whole? And that's where you're looking to life insurance. Other things you can look to are setting up. Some people will set up an account, right? Like almost a savings account. I think that's harder to do if you expect a higher value. So you kind of have to think through the different options. I think the most common fallback tends to be insurance, but it really just depends. There's different options. In a small firm, you should have a mechanism so that the other partner or your key employee that you work with has some mechanism to have the ability to locate, passwords, your case info, because each of you sitting at your computer right now have at least one password that is unique to you. Hopefully you have a multitude more. And so if they don't have a way of accessing those, they might not even be able to see your email to deal with it, or they might not be able to get on your phone, to get whatever, the photos of the car accident seen off of them, or whatever the case may be, the confession video. So you just need to make sure that people have access to those things, and also just to your files generally and your accounts, right? So, and that's for a small firm. That applies for a solo practitioner, but again, that's part of your assisting attorney that we'll talk about. Inventory counsel and assisting attorney. These are the other two things in this list for ways to address this permanent absence. Well, inventory counsel is built in, right? So it's sort of like when I do estate planning with clients and I say, hey, if you don't do a will, that's okay. The state of Colorado has one for you. It's written into the statutes. I'm going to bet you may not like it exactly the same that same way you'd like what you would do, but it is there if that's what you need to do. It's sort of the same way with inventory counsel. We have it there and it will jump in if needed, but you can do assisting attorney documents and planning to sort of avoid that road, right? But it is there as the other option. So now we're going to talk briefly about making your own plan. So the reality with talking about making your own plan is we can't get into all of the details. There's just no way to get into everything today. So we're going to go through some steps to get you started. The manual is being shared. The OARC manual literally has documents in it you can use. So it has a starting point. Definitely, you can access the Word version on their website. Definitely, it's a good starting point. But also, and I'll just mention this now so I don't forget, I've talked to Kyle. I mean, if there's some interest in a part 2 where we get into the meat of doing the plan and going through the manual in more detail and the types of documents that you would do, more than what we're going to talk about now, let Kyle know. We can look at whether there's interest in a part 2. But let's start now with making your own plan. First, you got to get yourself in order, yourself and your firm, right? And that's everything from that billing, the calendar. You just got to get paper cleared off. You got to get your files situated. Then with solos, you need to think about an assisting attorney. That's not going to be necessary for a small firm. So I guess the other option for a solo is to say, I'm going to find a partner because I don't want to do an assisting attorney plan. Okay, if that's your motivator, good for you. But for a solo, think about an assisting attorney. And then whatever you are, solo or small firm, get your documents in place. So getting in order, step 1, You need to have a calendar system that's workable. It's got to be up to date, accessible, staff in the know. That's the first thing you can do. You could do that theoretically this weekend. You could trigger some time, and that's when you're going to just get that part of it workable so that everybody can look at it and know what's going on if you suddenly aren't there. Step 2, take some time and get your trust account management done. If you've been negligent on keeping all your ledgers up to date or getting things reconciled, block some time and get that done. So make sure your ledger is clear. If you use case management, make sure you've got everything entered in there so they can look at it and say, you know, Sally has $55,000 in her Coltaf account, and we can print a report off of her case management off of Clio, let's say, and I can see exactly who has what share of that 55,000. So if, you know, Sally, I think is the name I used, if Sally died, boom, we can say where the money goes. If we have no other information, at least we know that's happening. But can someone accurately return funds, right? Maybe you had a client call in that just needed this one little project. And so you set them up in your system, but you didn't put any contact info. They probably can't return money, right? Organize your step 3, take another block of time and organize your client files. This is your file destruction policy. You got to deal with a file destruction policy. Too many people have way too many files in their office, and an assisting attorney will definitely be cursing you if they're coming in and you have, you know, a storage locker full of files somewhere. And so will inventory counsel. But also these other things, communications, file contents, can they tell what property you have? We have rules that say they have to be able to identify the property we have for people. If we're holding, you know, whatever, assets out of a probate estate because they're fighting over it, can they track it? File retention. I put a couple slides in here. Again, this goes to your ethics, hopefully. Rule 1.16a, go back to it, get a refresher on it. I think it confuses. Sometimes it can get confusing because of the way it's written. But the reality is, if there's no pending or threatened legal proceedings known to you, at a certain point, you can get rid of that file. And you have to follow the guidelines as to how to do it. You can give it to the client, or if the client authorizes in writing that you can destroy it, boom. So, you know, that might require you to start sending out letters. Truthfully, that's kind of a pain, but sometimes that's what you have to do. But if you give written notice in advance, then you can also destroy them that way. And then there's also a 10-year. So if you've got files more than 10 years, you don't even have to give notice, just get rid of those things. The notice requirements from this point on, one of the things to do is clean up your fee agreement. Put a provision in there that says our file policy on client file destruction and retention is as follows. If we don't hear from you within 30 days of closing your file, requesting copies or requesting the file, then we are going to shred the file and get rid of the paper file. And in my office, we scan things. We do keep some digital files, but we also in the fee agreement say digital files can go away after a period of time. And so we put a cap on that. The reason is, if I put a 2-year cap on it and then I die, my assisting counsel can come in and go through closed files, and if they're more than 2 years old, they can just shred them all. They don't have to worry. They can delete the digital file. They aren't calling people that haven't talked to me for years. But if you put it in your fee agreement, that fixes it. Also, keep in mind, you are not required to keep multiple copies or drafts of documents. Sometimes people have multitudes of copies and their draft workings. You don't have to keep all that. Even for the 30 days, none of that applies. You don't have to keep those. Also, the rule does not require you to have a paper file. So get a good scanner and become digital. It's going to cut down on your space in your office, and it'll just start making life easier for that assisting attorney or for yourself if you go to close your practice. Step 4, billing and time entries. We've talked about this. Step 5, access. Can people get access to your digital files, your accounts? Do you have a central location where they can get this key information? Insurance, again, we've talked about that briefly as well. One other thing on insurance that I will touch on is another way to address your assisting attorney situation is to keep in mind that if you have some life insurance, so for instance, I'm a sole practitioner, I have 2 employees, I've offered, or I have life insurance policies that my employees are opted into at the firms as a benefit. And so as part of that, there's a policy on me. If that goes to my firm as the beneficiary, that can then fund my assisting attorney and my office expenses, even if just briefly, to let them get up and running, right? So the idea is to think through ways you can use insurance to help cover your cost if you're not there. We've talked about these, the buy-sell agreement, and this is for small firms. For solos, this is your assisting attorney. So if you want to designate someone to avoid OARC, now you need to create the actual succession plan documents to do this through the OARC manual or through working with an attorney to get a more customized plan in place. It can be simple, it can be complex. Decide if you want that assisting attorney to decide if you're disabled or incapacitated, because you can give a release to give them the power to make that decision. Basically, they have to consult with a medical provider. You can also decide if you want them to represent you, your clients, or no one in the equation. Representing you and the clients can create conflicts, so you have to think through how that would work, especially if you're a litigator and they could potentially have conflicts. Are they going to be paid? And if so, where's the money coming from? So these are the documents you use to do that. An agreement to close your practice. That can be simple or complex. There's 2 versions in the manual. That's giving them the powers and defines what those powers are. A limited power of attorney to access things like your bank accounts. Again, it's limited, so it's just tied to your firm. HIPAA release. This is giving them access to medical information if they're helping get determination that you're incapacitated. A letter of understanding, that's if you want some extra protection in there so that maybe somebody else is holding the limited power of attorney and then turning it over. An authorized signer form for your bank. You go through the bank to get that paperwork. Will or trust provisions. Your assisting attorney documents are somewhat ineffective if your will and trust don't kind of empower them as well. Everything has to work together. Updating your client engagement letter. Mine says something about if I'm, incapacitated or die, and then it gives some language about what happens. It's pretty short. Then you have to give information to that assisting attorney. If they don't have your list of contacts, they don't know who to call, they don't know what to do to get into the office, then they're going to have problems. A procedure manual helps them as well. Okay, I flew through the last few because I want to give you time for questions, but this is the link. And again, I know Kyle has the link as well, and I'll put it in the chat here in just a second. But that's the link to the form on Office of Attorney Regulation Council's website. And then I believe we're to the questions part. So I'm going to pull up the chat. Maybe I'm just going to stop my sharing. All right. So I can see the chat. I don't see any questions in there yet. Does anybody have any questions while I grab this and put the link in there? I know I rushed through part of that, so I welcome any questions that you might have, or criticisms. Okay, I'm putting the link in there for OARC, so you have it. And then there's not any questions. We'll finish up a little early. Let's see. Could you talk a little more about the buy-sell agreement? Sure. So I don't know if there's something specific you kind of want to talk about there, but essentially the idea with the buy-sell is coming up with an agreement, generally, like let's say it's a two partner firm, right? So it's an agreement that's part of your, oftentimes done when you really build the practice or your initial documents, setting up your practice documents. And basically what it is, it's an agreement between the 2 partners, but it could be between, you could set it up even sort of one-sided, but generally it's between 2 partners, and it basically says, hey, if something happens to one of us, this is what happens to our interest. And then you say, if I retire, if I die, if I'm incapacitated, the following happens to my interest. And maybe it is that the other partner has the right of first refusal. So maybe they're not forced into a purchase if they don't want to take it over. But it just depends how you two work it out, or it could be more than two, but you're working it out. So there's an arrangement that says that something is going to happen if one of those triggers occurs, that the person who, let's say, dies is going to see some value come back to their family, because there's an agreement that they will sell so that the spouse of the deceased party doesn't come in and go, hey, I'm your new partner. We never got along, but let's do this thing. So you're avoiding that because the survivor doesn't have to partner with them now. The surviving partner comes in and says, I'm going to buy you out under the buy-sell agreement. Here's your money. And then they now have everything. The question becomes, how do you pay for that? That's where you start looking usually at insurance, unless you just plan to fund it yourself. Sometimes it's payments. So sometimes you'll see these set up where, they'll buy it out over a period of time. And that's why you'll see people still getting income out of a firm after a retirement or after a death. And it's because they've reached some sort of an agreement that continued over time. I don't know if that kind of helps at all, Margie, or if you have some further questions. Can a non-attorney heir even own partnership interests? Not in a law firm. No. Just like we have this with therapists too. That's why I said they're similar. You have to be licensed to own a law firm. So they couldn't keep it. So if the wife wasn't an attorney, they can't keep it. They have to leave the firm. And sometimes there's no value going to them. I've seen that happen where they don't get anything out of the firm. And so that's why it's good to think through it now, so you don't end up with no value. So. And the other thing too, I should say about small firms, I don't think I touched on, there's also a type of insurance out there called a key person policy. I'm not an insurance advisor, so I'm not going to give you a bunch of details on it, but I know if you have a key person, and there's more than one key person in the firm, you can actually get insurance on the key people, the firm can, and it's a way to then, if that key person dies, you've suddenly got this insurance policy paying in that helps you replace that key person. And according to the folks I've talked to in the insurance industries, there's a lot of different ways to use that. But again, I'm not an insurance expert. So it is something that is available generally, especially to small firms. When you've got, when you've got like two attorneys, the firm can buy key person insurance so that there's some way to replace their earning capacity in the firm, because you're losing their billing, right? So, and it looks like Kurt might know about key person insurance. So there you go, Kurt. I'll let him reach out to you, because that's the extent of my knowledge. So other questions, guys? Like I said, I know I rushed through some of that, but it can be a very broad topic. I'm happy to answer any questions. You're also always welcome to email me or give me a call if you have questions and you're trying to set it up. As you try to set up your plan, really you're trying to think of who that assisting attorney can be. I've already told you there's a lot of us out there that are solos according to the numbers, so you got a lot of options. If you can't find someone that matches for you, there's other options available, including, I know Solo Small Firm section through the CBA was putting together a list at one time of people looking to be matched. I don't know how effective that ended up being. But there's some other options too. Just reach out. I'm happy to visit with you. So I think that's our time. Kyle, did I miss anything?
Yeah, no, that was great. Again, I will send out Jody's contact information along with the presentation materials. And I will point out Jody's presentation made me check, and the CLE form I do have, but they overlooked the ethics portion. So I'm going to follow up with the office to try to get that partial ethics portion. So I'll send the CLE form that I have, but know that I will be following up, and we'll get a new form and I'll send that out once I receive it. Usually it takes a few days. So I apologize for that oversight. But again, thank you so much for presenting, Jody. Please, if you have any questions, you can always send them to me. And if you have any suggestions for future programs, talk to me or to Joe Enzor, our incoming Solo Small Firm section chair. And thank you especially to Kurt Hofgaard and Hofgaard Insurance for sponsoring this wonderful program today. We'll let you know about part 2. Reach out to Kurt as well. Thank you, everyone.
Thanks, everyone.
Have a great day. Thanks again, Jody.
Bye.